Good morning, good afternoon, good day, and good evening. I don't know what time of day it is for you, but for me, it's a good time of day. We're back at it again today. We are here. It's another marvelous Mediation Monday, and we are talking about none other than mediation. What could we possibly cover in addition to what we already have in regards to mediation? We already talked about what mediation is. We already talked about 5 truly compelling reasons on why you need mediation in your life today if you're going through some kind of court proceeding right now. What else could we be discussing about mediation? Well, before we jump into that, I want to toss in that disclaimer. What disclaimer you might be wondering? This disclaimer. That while we are talking about a legal subject today, this is not, and I say this as emphatically, I say this as explicitly as I possibly can. This is not, and I repeat again one more time for emphasis, this is not legal advice. What this is, though, is a discussion about that legal topic of mediation. And we're going to be talking today specifically about that process, that litigation life cycle. We're going to be talking about the 4 things that normally comprise it, and at what point you can jump outside of that process and into some kind of settlement, specifically into mediation. Let's get to it. And we are back, and I'm glad to have you back. So what is this litigation life cycle? What are these 4 things that we're talking about that we need to consider that helps us to understand exactly where it is that we're at in that process and when we can jump outside of that process and why it is we want to jump outside of that process? Well, let's talk about it. This is for all of my attorney friends out there. This is going to be an oversimplification of the process. We're 4 parts of that process. We're talking about the pleadings. We're talking about discovery. We're going to be talking about the trial, and I know there's a pre-trial, and then there's a post-trial. That includes the appeals process. And as you're going through this process, there's a time when you want to jump outside of it, and you're working in what they call the shadow of the law. You're still in this process. You're working in the shadow of the law to get to some kind of settlement, to get to something where you don't have to go through the complete process. And why you might want to consider that, and at what point you want to consider that. Well, and understand that if you're suing someone or you've been sued, so you've either been served for the summons and complaint, or you're serving someone with a summons and complaint, and then they get a period of time, and it's going to differ slightly whether or not it's federal or here in the state of Texas. If it's state, they have a set period of time in which they can reply and provide an answer to your summons and complaint, or they can provide a pre-answer motion rather to your summons and complaint. So depending on what that is or that answer is, if like an indefinite statement that goes back and forth, that could be anywhere from a few weeks to months. And it shouldn't take months normally. It should only be, depending on whether or not you're federal or state, it's going to be slightly different as far as whether or not it's 21 days or the 30 days that you're dealing with. Here, you have a process of possibly months, because then they might come back and ask you, well, we need a more definite statement. We don't understand what it is that you're asking for. And in that case, you got to amend your pleadings, and that can go on for a little bit of time, depending on if they wait to the full end of it, then they serve you, and then it goes back and forth. In any event, that happens. Once that happens, then comes what is by far and away the longest part of this litigation life cycle. What is this longest part? We talked about discovery. Why is discovery so long? Well, this is when documents began to be exchanged. So now you're dealing with a document exchange. You're dealing with interrogatories, where that's just a fancy word for you get served with some questions. You got to answer under oath. You get depositions. And again, not really get into it where the parties can come in and they're there with the attorneys and a court reporter, and they're under oath and they're answering these questions. You have requests for admissions. There's all kind of things that are happening. You want a witness list. You want to know who the witnesses are going to be, who the expert witnesses are going to be. And this is not like in the old days where maybe 500 years ago or whatever back in English times, when they could have this surprise where all of a sudden it's like, whoa, this evidence I didn't know about this evidence, or what you might see on these TV programs that depict these fictional depictions of court cases. That's not what happens at all. The discovery process means that as you're going through it, and once you get towards the end of it, everybody has all the information they need. They've asked all their questions. We know what the evidence is going to be. Before you get to trial, there's the pre-trial motions where you're going to decide what evidence. If you want some evidence to be suppressed, you don't want this evidence to come up, you do want this evidence to come in, and you guys are arguing about the evidence that can be presented at trial, that you guys have already talked about amongst yourselves as far as party to party. And you're going through this entire process. At any point in this process, you can jump outside of it, and you can operate with what they call within the shadow of the law. You're still within that process, but you can operate in the shadow of the law, and you can jump to the end of the process. You can skip the trial. You can skip where the judge or the jury, and if his family is definitely going to be the judge, but where they render a judgment and they give you a judgment, and then the judgment or the verdict, everything's going to be signed. The judgment will be signed, and all of that information or all of that paperwork then comes back. You can jump to that part where the paperwork's getting signed by the judge at any part in that process, up to where you're going through and you're in trial, or where you have a judgment. So at any point along the line, you realize this is more than I bit off more than I can chew. This is more than I anticipated dealing with. There's more information coming out that I don't want to become public. I would rather it be confidential. All of those things could play a part in why it is that you want to jump outside of it, into the shadow of the law, get to the end of the process, and have some kind of settlement between the parties. So the parties at any point can get in there and decide they want to have a settlement. And as a matter of fact, here in the state of Texas, again, most courts require some form of ADR, specifically mediation, prior to the case going to trial. So they want you to try and work it out between yourselves before you ever get to trial. And that's important. That's very, very, very big. So you might be looking at it and go, I'm not worried about the district courts. I'm in the Justice of the Peace Court. Now, in Texas, as of September 1st, 2020, I can bring a case before the JP. That's Justice of the Peace. I can bring a case before the JP for any civil case less than $20,000. Before September 1st, 2020, it was, if your case was filed before then, it was $10,000. But now it's $20,000. And I'm not even being represented by an attorney, so I don't have to worry about all those attorney's fees that you're talking about or retainers that you're talking about. I'm what they call a pro se litigant. I don't need to worry about it. Most courts still require, prior to getting to court, even in the JP, that you go through mediation, that the parties try to work it out. And even going through that process, you might look at it and you might determine these principles that you're sticking up for, principles are expensive. And you might realize that what needs to be provided, even though you're not up under the same rules of evidence as the district courts, this is a long, arduous process, longer than you were anticipating. Maybe we can just come to some form of settlement that'll actually get you what you were looking for, as opposed to what you actually had to put into your pleadings as far as what you were looking for. And that might be another way of going about it to get through to the end process, where you get either an MSA that's signed off and the terms of the MSA are met and the case is now thrown out, or you can get an agreed upon judgment where it's going to take you a while to pay it off. And in that time frame that you're looking at, you have an agreed upon judgment that if it gets defaulted, then it goes straight back to court, and you already have the judgment and you've already agreed to it on whatever that is. In either of those cases, those are both very advantageous outcomes. I know from my lawyer friends, some of you guys are out there, specifically here in Texas, thinking about Rule 11s. I don't want to talk about Rule 11s. I don't like Rule 11s. It's almost like having a contract that's a non-enforceable contract. It's acknowledged that we do have an agreement, but for the most part, that agreement, the terms of that agreement, it's really hard to get that upheld in a rule up under a Rule 11 as opposed to an MSA or an agreed upon judgment. That being said, we've reached the end. We have talked about the process to get us to mediation. And while that process might take a while, if you go through the entire life cycle, we can jump the line, so to speak, and get to the end at any point up till you get to trial. Jump outside of it and make sure that you get a settlement. So with that being said, we are done. It's another day. And if I haven't mentioned it before, I love you, fam. I'm sure that whatever point that you are in your day-to-day that you are absolutely killing, have killed it, or going to kill it. And I hope that you always